Welcome to Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney.
Hey all, welcome back to an all-new episode of Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney with attorney Joseph Jordan, the founder over at Jordan UCMJ Law Group. I'm your host, Mike Leon. In today's episode, Joseph here, who's a former Army JAG, worldwide court-martial defense attorney who's tried more than 240 court-martials to verdict and handled hundreds of military cases all across Europe, US, Pacific, and the Middle East. We're going to be talking about how he does his opening statements, not as a performance, but as the moment where control, credibility, and that narrative momentum begin to take shape in the courtroom. Joseph, it's good to see you as always. I know a little bit about performing. I'm doing it right now to an extent. But for you on the opening statement front, when you stand up for an opening statement, what are you kind of trying to establish in the room before you even get into the set of facts around the case?
Good morning, Mike. Thank you again for having me. What do I want to establish? Well, first and foremost, you want the jury to know you, like you, and trust you. And you start that during the voir dire process, and they get a sense for your tone, your pacing, your intonation, those sorts of things. And then in the opening statement, you continue that and you remain consistent. And they start to get a sense for, one, do I like this guy? Can I trust this guy? And is he going to give me the information that I need to make the decision in this case? And so you want them to know you, you want them to like you, you want them to trust you. So you give them a set of information that you know in your mind, for the most part, is bulletproof, right? I want to give them a roadmap as to what the defense case is, all right? They need a roadmap for that. Some defense counsel take the approach, no, we're just going to kind of soft play it, those sorts of things. That is typically not the way I do things. I want to give the jury a good, clear, concise roadmap and give them expectation management on what's coming next.
Let's break apart something that we've also talked about in previous episodes, right? Because you've got a little bit of this bridge between voir dire and the rest of the trial actually happening. So the panel's already been selected, right? You're getting the impressions that are starting to form. How do you personally, how do you start thinking about the opening statement as we have this little space in between the voir dire and the rest of the trial?
I'm going to start by saying that I have a philosophy for trying cases, right? Anybody that's successful has a philosophy for doing a certain thing. And my philosophy for trying cases is quite simply, tell them what you're going to tell them, tell them what you just told them. That's number one. Number two is, if you're going to advocate to members, then that advocacy starts during jury selection. They get to know you, like you, and trust you there, okay, with the types of questions that you ask, the follow-up questions that you ask. And then that continues over into opening statement. That continues over into the same attorney cross-examining the main witnesses in the case. That continues over into the same attorney that's did the other main parts of the case, giving closing argument. What does that give them? Consistency, right? Consistency is really important. Just like a football coach coaching his team, the players want consistency from their coach so that they can know them, like them, and trust them to lead them to victory, right? So in this scenario, when I'm looking at opening statements, and I don't think of them as opening statements, I think of them as opening argument. I actually, my opening argument starts with my closing argument. I draft my closing argument first, and then I pare down from my closing what I want to give them in opening, so that they are nested and so that they are consistent.
Speaking of like them, we talked in a previous episode about your jury service and whether or not, liking the attorney, what they did in terms of pacing back and forth, the tone that they would take. What do you pay attention to about you yourself to make sure that the room is staying with you during this opening argument?
That's a good question. What am I paying attention to for myself? I guess one, it's the message. What is the message I want the panel to receive? And how am I delivering that message? And can I feel confident that the message that I'm delivering in opening argument is going to be the message that comes from my cross-examination of government witnesses and from whatever case I decide to present during the defense case in chief.
So staying on that just for a second, though, real quick. You've probably have seen opening statements that have fallen flat and others that have grabbed the attention. I asked you about how you command a room, but like from your perspective, what kind of separates the two without relying on the theatrics part of this?
Does your advocacy, does your words advance the narrative, right? Are you continuing to advance the narrative of where you want the jury to go with this? That's the main thing, right? What are the points in which you know you're going to attack the government case? Now, you don't reveal everything in opening statements, but you can signpost things. Hey, panel members, pay attention to my cross-examination on this point, right? Pay attention to my cross-examination on that point. There's going to be some really interesting evidence that comes out here, here, and here. Watch what I do with it, right? Those sorts of things.
One of the other things that, again, this is more on the civilian side that I could speak to, but I'm sure for you, the opening statements can maybe create some sort of confusion that you don't want, or they can paint a real clear picture. In your presentations to these panels, how do you make sure the panel understands what really matters on the onset of this case from the very beginning without losing them?
Sure, that goes back to my preparation. As I stated before, I draft my closing argument before I draft my opening argument. And so I know where I want this case to go. I know where the facts are going to take me. I know where my cross-examinations are going to take me. And so I keep it on track in opening, right? And I make sure that my opening statement is specifically targeted to the information that I know is going to come out, that I know 100% is going to come out. There's absolutely no way that it's not going to come out, okay? And very rarely do I roll the dice on information in opening statements, because if you overpromise in the opening statements, you will lose the jury throughout the case. And you don't want that to happen. So you can't overpromise. You stay focused on the facts. You stay focused on the facts that you know are going to come out over the course of the trial, and that's what keeps you on track.
Man, that's a message for life. Don't overpromise, right? Can you, Joseph? Let's get into the personal experience side. Share a story with us or a case where something you did or maybe you didn't do in the opening argument that you make, it noticeably affected how the rest of the trial unfolded for you. And what kind of stood out to you about that experience as it unfolded?
So many of my cases that we've gotten full acquittals on, it's giving the roadmap, and the roadmap plays out exactly the way you think it will, or some semblance of it. And there's no surprise on the back end on what happens. But I do have one case that's pretty memorable, and it's just because of the nature of the facts and some of the reactions that I received on the particular facts. So this was a case at Fort Riley, Kansas. My client was accused of sexual assault. It was a situation where he was accused of going into the soldier's barracks room, tying her up, and raping her. That was the allegation. And so we started unpacking the facts of the case. And this was a young lady who was very proud of her accomplishments in the gym. And I noticed that through looking at her social media. And this case was pre-COVID. And social media was a big deal 7-8 years ago. It's a big deal now. But we looked at her social media, and we noticed that she was big in the gym. And so I questioned her on it in an interview, and she confirmed it. And I was curious as to how much do you squat? How much do you leg press? Those sorts of things. Found out she leg presses 750 pounds. And, internally, I'm thinking, wow. So in my opening statement, and you're going to find out that she leg presses 750 pounds. And I saw a couple of jury reactions to that. They were like, what? And so then when I cross-examined her in the actual court-martial itself, those same jurors that reacted to my opening statement with that particular fact looked at me, nodded, and gave me they looked at me, they nodded, and they gave me a nod of approval with a bit of a smirk on their face. And that particular fact was very, very indicative of pointing out kind of the fallacies of her claim, right? So, and that was really, really important. Understanding that, what she is saying doesn't make sense. How she described how she was assaulted doesn't make sense in light of the fact that she is a very strong individual. What she had alleged didn't pass the common sense test, and the jury saw it that way as well.
It's an example to not put everything out on social media, folks. As we kind of land the plane here on this episode, Joseph, for people that have been following this series along, what would you want them to understand about why the opening argument, not that statement, the opening argument isn't about winning the case, but it's about setting the conditions for everything that follows?
I think you said it. You want to ensure that the opening argument will lay a roadmap for the members, that they will feel comfortable with what they're about to see. You want to give them a sense of, oh man, I'm looking forward to seeing how this unfolds, right? It's kind of like watching a promo for a film, right? You go back to right at the beginning of the year, Avatar was released. How many promos were there for, the third installment of Avatar, the film? And how excited were people getting to go and see the film, right? Or Star Wars, for instance. Everybody's excited about The Mandalorian and Grogu, right? We're watching with rapt attention, like what's going to happen, and starting to think about what are we getting ready to watch. Well, with an opening argument, it's a little bit more visceral than that, right? You're really laying out what's going to happen, but you want to give that sense of, man, I want to hear what this case is really about, right? This is not going to be a boring situation here. I'm actually going to be involved. I need to really listen and pay attention. And that's what you want the members to take away from that experience and listening to your opening argument.
Yeah. Joseph, can't thank you enough for the time, the insight, sharing your experience on all this. I appreciate it as always.
Thank you, Mike.
And thank you to everyone out there for listening to this episode of Courtroom Quarterback with Attorney Joseph Jordan. If you want to learn more about Joseph's worldwide court-martial defense practice, do me a favor right now, visit jordanucmjlaw.com. Before you go, do me a favor, please like, subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.